Hello, and welcome back in. Welcome, people. Welcome, people. You all saw the moniker. I appreciate all my old followers and my new people. Uh, please hit the like, share, and subscribe. Now, the appeal of Karmelo Anthony. And I was under the impression, and I have, heard rumors, seen that they have filed an appeal. Of course, they were going to file an appeal. He has a right to file an appeal, specifically if he doesn't think his verdict was correct. And rightly so. Any person that feels as though their verdict is not correct, they should be filing an appeal. And Karmelo Anthony is no different, right? So, I've been going over this trial, reading transcripts, reading people's responses, reading other things that have been offline. And I keep coming back to the same question, the very same question. If I had been sitting at that defense table, would I have handled this case the same way? And the more I think about this, the more I think the answer is probably not. Now, before anybody gets into the comments, twisting my words, let me be very clear about what I'm saying and what I'm not saying. I'm not saying Karmelo Anthony was innocent. It's not what I'm saying. I'm not saying Austin Metcalf's life didn't matter. A 17-year-old boy lost his life, and 2 families have been destroyed by what happened under that tent. 2 lives, 2 families have been destroyed because of what happened under that tent. Not just 1, 2. Nothing about this conversation changes any of that. But that's not really where this case is anymore. Everybody wants to argue about whether Karmelo Anthony was guilty or innocent. Everybody wants to pick a side. Social media has already divided itself into the camps. One side believes this is a clear-cut murder case, and the jury got it exactly right. The other side believes this was a frightened teenager who reacted in a split second and got swallowed up by a system that showed him no mercy or grace. But the jury has already spoken. I'm sorry, the verdict is in. 35 years. For now, that chapter is closed. The question now is a different one. The question now is whether Karmelo Anthony got the kind of defense every American citizen is supposed to get when the government comes after them with the full weight of the criminal justice system. Because I think a lot of people misunderstand what a defense lawyer is actually there to do. A defense lawyer is not hired to prove their client is a saint. They're not there to tell you that a tragedy did not happen. They are not there to erase a victim or excuse his bad behavior. A defense lawyer has one responsibility above all else: to make the government earn every single inch of that conviction. Their job is to challenge that evidence, to question the witnesses, to object when the rules are bent, to fight for every favorable jury instruction, to preserve every issue for appeal, to make sure that when the state takes away a person's freedom, it does it exactly the way the Constitution says it is supposed to do it. Because if the defense lawyer doesn't do that, nobody else in that courtroom will. The prosecutor's job is to secure a conviction. I get that. The judge's job is to call balls and strikes. The jury only decides the case that is put in front of them. That means there is exactly one person sitting in that courtroom whose entire purpose is to stand between the accused and the enormous power of the state. And here's the part people don't like to hear. A good defense lawyer is supposed to make us uncomfortable. A good defense lawyer is supposed to challenge the government's story. They're supposed to force the prosecution to prove every element, expose every weakness, and answer every doubt. They're supposed to leave absolutely nothing on the table. Nothing. Because one day it might not be Karmelo Anthony sitting at that defense table. It could be your son. It could be your daughter, your grandson, your husband, somebody you love. And if that day ever comes, you don't want a lawyer who simply shows up and has a suit on. You want a lawyer who fights for every inch, who raises every objection, who preserves every issue, and who gives an appeal court something to work with if things go wrong. And that's what keeps bothering me about this case. The more I read about this trial, the more I go back through the testimony, the jury selection, the legal arguments, and the sentencing, and the more I keep asking myself the same question. Did Karmelo Anthony lose because the evidence against him was simply too strong? Or did he lose because his own defense team failed to fully develop the arguments they had available to make? Because when I look at this trial, I don't see a case where there was nothing to argue. I see a case where there were legitimate legal issues, strategic choices, and unanswered questions. I see a case where reasonable people can ask whether the defense pushed hard enough during jury selection, whether they put too many eggs in the self-defense basket, whether they should have let Karmelo testify, whether they fought hard enough for every jury instruction, and whether they did enough to humanize a 19-year-old first-time offender before a jury that would ultimately sentence him to 35 years in prison. And that's why I think this appeal matters. Not because it erases what happens. That's what y'all keep thinking that it's going to do. It doesn't do that. Not because it guarantees a different outcome. No, but because our legal system was designed to ask one final question after the verdict is read. Did those lawyers do everything the Constitution requires? Or did they leave too much sitting on that table? And if I was a lawyer, if I was his lawyer, there are some things I think I would have argued very differently. Did Karmelo Anthony get the kind of defense that gave him a real chance? Because an appeal is not about pretending Austin Metcalf didn't lose his life. He did lose his life. He's dead. And that is heartbreaking. A family buried their son. A twin buried his twin. Friends and classmates will carry that loss for the rest of their lives. Nothing about an appeal changes that reality. And an appeal is not about saying Karmelo Anthony didn't make a terrible decision. He did. He made a fatal decision. A 17-year-old boy is dead because of what happened under that tent. The consequences of those few seconds are permanent. But an appeal asks a different question. It asks whether the process worked the way it was supposed to work. I don't want to fucking hear what you think. I want to hear what the law thinks. Did the lawyers make the right call? Decisions. Did the judge make the right call? Decision. Did the jury receive every instruction the law required? Was the defendant given every protection the Constitution promises? Regardless of whether people like him or dislike him, you can like him or not, doesn't matter. Because if the answer to any of those questions is no, then the system has an obligation to take another look. And I think that's where a lot of people get uncomfortable. We tend to think that once a jury reaches a verdict, the conversation is over. But our legal system was intentionally designed with multiple layers to it. Trials happen, appeals happen, then in some cases, additional reviews happen after that. The reason is simple. Human beings make mistakes. Human beings have biases. Lawyers make mistakes. Judges make mistakes. Even juries can reach decisions based on incomplete or improperly presented information. The appellate process exists because juries or justice is not just about getting a conviction. It's about getting the process right. And the more I go back through this case, okay, the more I find myself asking one uncomfortable question. Did Karmelo lose his case because the evidence was overwhelming or because his own defense team left too much sitting on the table? Now, let's be clear. I'm not his lawyer, and I'm not pretending to be one. I'm not giving legal advice, not at all. And I'm not claiming to know more than the attorneys who were actually in the room. But I have followed enough high-profile trials, been in enough courtrooms, did enough paperwork, and was on trial attorneys over the years to know that sometimes people don't lose because they have no defense. Sometimes they lose because the defense they had was never fully developed, or because strategic decisions that seemed reasonable at the time end up looking questionable about after the verdict comes back. And when I look at this case, I see at least 5 areas where I think appellate lawyers are going to spend a lot of time digging through transcripts, motions, and rulings. First, let's talk about jury selection. This is the question I always ask. Have you ever seen an all-black jury? Have you ever seen an all-black jury for a white person? That would be strange, right? So why would you have an all-white jury for a black juror, for a black defendant? Every experienced trial lawyer will tell you that a case starts long before opening statements. It starts with people who will eventually decide the outcome. You can have the best evidence in the world, but if the jury doesn't connect with your theory of the case, you're in trouble. Jury selection is one of those parts of a trial that most people skip over because it's not dramatic. There are no emotional witnesses. There are no surprise pieces of evidence. It's just lawyers asking questions and making decisions about who stays and who goes. But behind the scenes, it's one of the most strategic parts of the entire process. Why did they dismiss black people who could have been jurors on that trial? In this case, the defense objected when the prosecution struck several prospective jurors who happened to be educators. They raised what is known as a Bastion challenge, arguing that the strikes were improper. The prosecution responded that the decision had nothing to do with race and everything to do with the facts that this incident occurred at a school-related event. The judge accepted that state's explanation, and the trial moved forward. Now, I'm not here to tell you the judge got it wrong. That's not my role. And frankly, that's what appellate courts are for. But I do wonder whether the defense pushed that issue as far as they could have. The defense. Did the defense create the strongest possible record for appeal? Did they identify similar situated jurors who were treated differently? Did they preserve every objection they needed to preserve this evidence? Did they force the prosecution to fully explain its reasoning behind dismissing all the black jurors? Those questions matter because appeals are often less about what happened and more about what was documented. Appellate judges don't retry the facts. They review the record. If an issue wasn't properly raised or preserved, it becomes much harder to argue later. Let's hope those lawyers did that. And that's one of the frustrating realities of appellate law. You can believe something was unfair, but if the groundwork wasn't laid during the trial itself, the appellate court may not even be able to address it. So, the second thing that jumps out at me is the self-defense strategy. From the very beginning, Karmelo Anthony maintained that he was scared. Scared. Nobody can say whether he was scared or not. The only person that could say he was scared was him. So why didn't that boy get up on that stand? According to statements introduced during that case, he believed he was protecting himself. The defense built much of his theory around that idea. From the beginning, he said he was afraid. They pointed to the confusion surrounding the weather delay. They talked about the crowd, the tension, the physical interaction, and the rapidly unfolding nature of the confrontation. And to be fair, if your client says he acted in self-defense, you almost have to present that argument. That's the only argument that you should be focused on. You should dive in it like your life depends on it. You can't simply ignore your client's own explanation of events. But here's where I struggle. I felt like the defense put almost all of his chips on the jury, fully accepting his self-defense argument. And I don't know what they spent enough time building alternative plans, if they did or they didn't. But if the jury wasn't willing to go that far, they didn't present it correctly. In other words, what was plan B for this appeal, this self-defense appeal? What if the jurors believed Karmelo was afraid, but also believed he overreacted? What if they thought he perceived a threat, but used more force than was legally justified? What if they rejected complete self-defense, but still believed the circumstances were more complicated than the prosecution suggested. Those are the kind of gray areas that often exist in real life. Human beings don't always fit neatly into legal categories. An all or nothing defense can be effective when the facts strongly support it. But it can also be risky because if the jury rejects your central argument, they may feel like they have nowhere else to go. I kept saying this weeks and weeks ago. I said proportionality should be what this trial hinges on. Would a reasonable person be scared, overreact in those circumstances? Is his fear unreasonable? We can't say that, but we can only say how we would react. But his lawyer was supposed to present that to the audience. His lawyers were supposed to convince the jury that he was scared, that he was acting reasonably for his fear, for fear of his life. Okay. I keep asking myself whether the defense gave the jury enough room to see the nuance. Did they provide a framework that allowed jurors to acknowledge his fear, his confusion, and his panic without requiring them to completely accept a full defense claim? Maybe they did. I don't know. Maybe the jury simply wasn't persuaded. But from the outside looking in, it felt like the strategy depended heavily on one outcome. Either the jury believed Karmelo acted lawfully or they didn't. And once they decided they didn't, the rest of the case may have fallen into place. That's why the verdict came down so fast. That's what I believe happened. Then we come to what may be the biggest question that I have at all to the whole thing. Why didn't they let that boy testify? Why didn't they let that boy testify for himself? He's fighting for his life. Y'all could have coached him. Y'all could have did whatever y'all needed to do. Why didn't y'all let that boy testify? I understand why defense attorneys often advise clients not to take the stand. Once a defendant testifies, prosecutors get to ask difficult questions. But this boy was a student. This boy apparently was not a hoodlum that ran the streets. This was not a person who brought a knife to a place and went there to kill someone. He didn't go there to do that. That wasn't the point. If it was raining, if it was not raining, he never would have probably been under that tent. So how do you prove and let someone put murder on somebody's jacket and that was not their intent? So, like I said, I understand when defense attorneys tell their client not to take the stand. Once the defendant testifies, prosecutors get to ask difficult questions to this witness, the perpetrator or the guilty party. They compare testimony to prior statements. They challenge inconsistencies. They confront the defendant with evidence and witness accounts. A cross-examination can undo weeks of careful trial preparation in a matter of minutes. That's the whole point of prepping your client. There's also a reason the Constitution gives defendants the right to remain silent. The burden is on the state to prove guilt. A defendant does not have to prove innocence. If you're fighting for your life, I ain't standing there. If I'm fighting for my life, I'm not standing in the corner and letting people tell my story. I'm going to tell my story. If I'm going down to shoot, if I'm doing 35 years and I'm facing 35 years, I'm pulling everything out of my fucking hat to prove that I was scared enough that I acted in self-defense. Ain't no way I'm sitting on the fucking bench and not saying nothing. Why didn't they let that boy testify? But then again, self-defense cases are a little different. At the heart of self-defense claims is the defendant's state of mind. What did he believe was happening? He said he was afraid. What did he perceive? What did he fear? Did he honestly think he was in danger? Did he believe he had another option? My understanding was this was a smaller boy than these two older guys, these two twins or whatever. After all this evidence is coming out, from the beginning, we heard that this guy went over to him and said, get out, and he's bigger than him. Okay. So it's reasonable to expect that he was afraid to a certain extent. Okay. The jury never got to hear Karmelo's answer to those questions in his own words. I'm jumping up and down. I'm on the stand. No, I don't want to hear about it. I'm not taking it because I'm not going to the stand, because this is what I felt at the time. I did not go there to kill anyone. I did not go there to hurt anyone. I did not do any of those things. I ran under a tent in the rain, and these two people come out of nowhere telling me to get the fuck on. That was not my intent when I walked under that tent. And a 35-year sentence makes it seem as though he walked under the tent to murder someone, which tells me that the defense didn't do their job. What was he thinking? Was he scared? Did he think he was trapped? Did he think he was about to be attacked? Did he believe he had any safe way to leave the situation? Instead, the jury had to piece together his state of mind through statements of other people, introduced by other people, and through the arguments made by his attorney. Now, maybe that was the right strategic decision. I don't know. Maybe his lawyers believed the risk of cross-examination outweighed the benefits. Maybe they thought the prosecution would tear him apart on the stand. Who knows? Maybe they worried that one poorly worded answer would destroy the entire case. It was just like a 35-year sentence for a 17-year-old boy who didn't have any intention of killing anybody, hurting anybody at all when he walked under that tent. It's just like y'all never shouldn't even have a trial. It was just like y'all didn't even have no trial. They just gave him a sentence. That's what it feels like. You just gave that boy a sentence. It's like nobody said nothing. There was no defense to that boy. No, he shouldn't have been under the tent. He just went there to murder Austin Metcalf. That's what it sounds like. That's what it feels like. 35-year sentence. No grace, no understanding that maybe he was scared, nothing. That's why you made a mistake when you didn't put the boy on the stand. But I also think it's fair to ask whether a self-defense case can truly reach its full potential when the person claiming self-defense never personally explains what he experienced. Jurors often want to hear directly from the defendant. They want to evaluate body language, tone, emotion, all those things, credibility for themselves. They want to know whether the fear being described feels genuine. The prosecution had the opportunity to present its interpretation of Karmelo's actions and intentions, and they didn't do it. Karmelo himself never had the same opportunity in front of the jury. Again, I'm not saying the decision was wrong. I'm saying it is the kind of strategic choice that people will be debating for years, especially if this case moves through the appellate courts. Next, then there was the jury instructions. Jury instructions. This is one of those issues that sounds technical and boring until you realize how important it really is. Most people think the evidence decides a case. In reality, the evidence and the instructions work together. The jury tells the judge tells the jury what legal standards apply and what verdict options are available for what you can find him guilty of. Those instructions become the roadmap the jurors use during deliberations. The defense wanted additional lesser included offense instructions. The judge declined those. Basically, what I'm saying is when the defense said, hey, put manslaughter on the table. Hey, put manslaughter 1, manslaughter 2 on the table. Put those on the table because y'all as a jury could probably decide that maybe he should get that. The judge said no. Why did the judge reject the lesser charges? Unless the judge had his own personal bias included in that judgment not to let lesser charges go. So the jury had fewer options than the defense believed that were appropriate. Now there are legal standards that determine when a lesser included instruction should be given. It isn't automatic, right? The defense has to show that the evidence supports lesser charges. Why didn't the defense put support on the table for those lesser charges. The judge has to decide whether the law allows it. But here's why this matters. Juries don't always see a case in black and white. Nobody sees a case in black and white like this. Sometimes they think the prosecution overcharged the case, but they also aren't prepared to completely acquit that defendant, which should have been on the table here. I'm not saying Karmelo should walk free. I am saying 35 years is too much. Also, jurors may believe the truth lies somewhere in between those two things, murder and manslaughter. Lesser included offenses exist because real life is messy. Real life is not straight and narrow. He did not go under the tent to kill anyone, which should have took murder off the table. They allow the jurors, these lesser offenses allow jurors to match the verdict to the facts as they understand them. Imagine a jury that believes Karmelo acted recklessly, but not with the level of intent argued by the prosecution, which is what I believe. If they don't have an option like manslaughter 1, 2, 3 on the table, if they don't have those on the table and the judge says, no, we're not going to put those on the table, so you got to decide on murder or no murder. If the judge says you got to decide murder or no murder, they don't have those other options on the table. If they don't have an option that reflects their view, they may feel forced to choose between those two outcomes that neither side represents fully, getting acquitted or murder. They didn't have a choice. That's why appellate courts pay close attention to jury instructions. If a legally supported instruction was improperly denied, that can become a significant issue on appeal. Will that happen here? I don't know. But I would be surprised if the appellate attorneys did not examine that part of the record very carefully. Another issue that deserves attention is the overall presentation of the defense case. Trials are not just about facts. They're about storytelling. The prosecution tells a story. The defense tells a different story. The jury decides which version makes more sense. Now, the version that the version of the prosecution put forward doesn't make sense. Murder, to me, doesn't make sense. Because his intent, I thought murder was the intent. You deliberately and willfully and recklessly went to kill another human being. That was your intent. That was not Karmelo's intent. Karmelo went under the tent to get out of the rain. Karmelo didn't go up to Austin and say, get the fuck on. Austin came up to him and told him to get the fuck on. If Austin would not have come up to Karmelo and said, get the fuck on, Karmelo never would have had any kind of interaction with Austin at all, because he didn't know Austin. So he would never have had the opportunity. This was a spare of the moment. I keep saying that wrong. Spur of the moment act. When I look back at the trial, I wonder whether the defense spent enough time giving jurors a complete picture of who Karmelo Anthony was before this incident, too. This was a first-time offender. No prior criminal record, a student, an athlete, a teenager. Those facts do not erase what happened, but they are relevant, especially during the punishment phase. He was not a thug. He was not a gangbanger. He was not a person that hung out. He was not a person who had guns. He was not that type person. He was an A student, no prior criminal record, no offender, an athlete, an A student. Could the defense have presented more character witnesses? Yes, they could. Could teachers, coaches, mentors, family, friends have helped paint a fuller picture? Could experts have testified about adolescent brain development, impulsive decision-making, or the way young people process fear under stress? Could have. We know that courts routinely considered youth as mitigating factors. The Supreme Court itself has recognized that teenagers often make decisions differently than adults because their brains are still developing. That doesn't excuse criminal conduct, but it can provide context. I don't know exactly what strategic calculations the defense team made, There may have been reasons for every decision, but from the outside looking in, I can't help but wonder whether they left opportunities unused. Because sentencing is not just about what happened. It's about who the defendant is and whether the court believes rehabilitation is possible. Listen to what I'm saying. Sentencing is not just about who the person is. It's not about what happened. It's a combination of all of those things and whether rehabilitation is possible. Next, there's also issues of the environment surrounding this case. This was not an ordinary local trial that unfolded quietly. It became a national story. Social media exploded with opinions before all the evidence was even presented. Every development was dissected online. Every witness was analyzed. Every rumor spread at lightning speed. That kind of attention creates pressure. It creates pressure on prosecutors. Now, let's be real. You guys remember that dude that was on the train that stabbed that white girl? Stabbed her in the neck on the train? Blah, 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 all that. Y'all remember that? How do you put Karmelo Anthony on the same level as that boy that killed that girl on the train? They're not on the same level. They're not. That's not the same case. That's not on the same. They're both not murderous human beings. Karmelo Anthony is not a murderous human being. This person was. Two totally different human beings. Two totally different separate cases. His intent, that dude on the train's intent, was to murder, harm someone. That was not Karmelo's thought. Two totally different people. Two totally different people. So, I'm saying to you, sentencing is not just about what happened. It's also about who the defendant is. What they have done previously before. Was that ever their intent? Whether the court believes rehabilitation is possible. Okay. Social media exploded, put him on the trial. Every witness was analyzed. Everything was dissected. Every rumor spread like lightning speed. That kind of attention creates pressure to the jury, to the prosecution, to the judge. It creates pressure on everyone because everybody's watching. It creates pressure on the defense attorney who know every move they make will be scrutinized. It creates pressure on judges trying to maintain order and fairness. And it certainly creates pressure on juries, even if they're instructed to avoid media coverage. I'm not suggesting that publicity automatically makes a trial unfair. Courts deal with high-profile cases all the time. But I do think it's reasonable to ask whether the extraordinary attention surrounding this case made it more difficult for the defense to do its job. Appellate lawyers often look at the totality of circumstances. They don't just isolate one issue. They ask whether multiple smaller issues taken together may have affected the fairness of the proceedings. Now, let me tell you where I stand finally. I am not saying Karmelo Anthony should have walked out of that courtroom. I'm not saying that. I'm saying if they found a guilty verdict, that verdict should have taken into account who he was, what he was, the circumstances, his fear, the proportionality of the crime. It should have been, all of that should have been taken into account. I don't believe any of that was taken into account because I don't believe the lawyers did their job completely like they were supposed to. So this is where I stand on that. I'm not saying Austin Metcalf's life didn't matter. It absolutely did. And nothing about discussing an appeal should ever be interpreted as minimizing that loss. So some of y'all need to shut the fuck up. What I am saying is that when you hand a 19-year-old first-time offender 35 years in prison, I want to know that every fucking safeguard in our justice system actually worked for that young man. I want to know every legal argument that could have been made was made. I want to know every objection that needed to be preserved was preserved. I want to know every strategic decision was carefully considered. And I want to know that the jury had every option the law says it should have had on the table. Manslaughter, 2, 3, 4, whatever the fuck. And when I look back at this trial, I don't walk away thinking there are no issues here. I walk away thinking there are real questions. And those questions are, did the defense do enough during jury selection? Did they lean too heavily on an all or nothing self-defense argument? Did they make the right call by keeping Karmelo off the stand? Did the jury receive every instruction it should have received? Did the jury receive other alternative sentences that they could have gave Karmelo? Did the defense do enough to humanize this first-time offender during sentencing? And did the extraordinary public attention surrounding the case create challenges that were never fully addressed? Those are not excuses. Those are appellate questions. Appellate questions. Shut the fuck up if you don't know anything about appellate questions. And that's why I think this appeal, his appeal, matters. Not because it erases what happened under that tent. Not because it takes away the pain of Austin Metcalf's family. I sympathize. I sympathize wholeheartedly. I lost a niece. I lost a niece to violence, and she was only 4 years old. So I understand. I feel nothing will erase anything under that tent. Not because it takes away the pain, like I said, from Austin Metcalf's family. Not because it guarantees a different outcome. It matters. This appeal matters because the justice system is supposed to check itself. If mistakes were made, they should be corrected. If they weren't, the conviction should stand. That's the bargain our legal system makes with the public. We accept the outcome because we trust the process. But the trust only exists if the process is actually tested and not tainted. That's what an appeal is for. So I'll be watching every filing, every hearing, and every decision that comes out of this case. I'll be paying attention to what the appellate lawyers argue, what the judge asks, and how the courts respond. Because sometimes the most important part of a trial is not what happens before the verdict. Sometimes the most important part is what happens after the verdict. And as I said, sure, he should be found guilty. But guilty of what is the question? Guilty of what is the question? So, if you like my commentary, please like, share, and subscribe. I appreciate it. I appreciate you guys coming out this morning at 11. I appreciate it. And I will be back this evening with more commentary, not necessarily about this case, but maybe something else might pop off. Who knows? I appreciate all of you guys. Please like the video. If you like the video, subscribe to the channel, please. And thank you. And I appreciate you guys. I appreciate you guys.